Everyone, thank you very much for our last session of the day today. It's our annual judicial panel. We've been doing this for several years now. It's a high honor and privilege as a graduate of this law school to be doing it. And it's also an honor to be serving on the committee. Another honor is that we have an incredible group of judges for us today. And moderator error number one, I do not have the slide clicker. Does anyone have that? The great team we have here. I realize, wait a minute, those aren't our slides. Thank you, Judge. Appreciate it. All right. And Judge Barksdale is not only excellent at the electronics that we all have here, she is also a very outstanding judge. Now, you can look up all their bios online, and Bill has told us that, and Bill will give me the hook if I go too long, but I do want to take a moment to introduce, there he is. I'm going to make the introductions more brief than usual. It's okay, Doug, you can contribute too, thank you, sir. I'm going to make them a little bit more brief than usual, but each one of these judges has unique skills and experience they bring to our panel. I'm going to be very quick on that, tell you where they stand, and then when you hear what we're going to do today, you'll understand why. First is the Honorable Patricia Barksdale. She is United States Magistrate Judge for the Middle District of Florida. Her experience is she has been in law firms and private practice for years. She was also a United States Attorney. She's also a corporate counsel. Bringing that experience, please join us in welcoming the Honorable, go Gators, a graduate of this law school, Patricia Barksdale. Next is the Honorable Gary Jones. He is United States Magistrate Judge for the Northern District of Florida, a long career in the law, and as a jurist, he was a litigator before ascending to the bench. In addition to that, he has heard, I believe, what may still be the largest multi-district litigation case that the nation has seen, the 3M case. In addition to that, he is also a member of the planning committee. When we all get together and plan this, he is intricate in this. And thanks for all your contributions. Please join us in welcoming the Honorable Gary Jones. Next is the Honorable William Matthewman. He is Chief United States Magistrate Judge for the Southern District of Florida. He brings a criminal law experience element to this situation, and he sees both sides of that. A former Miami police officer, he was also a criminal defense attorney. You can see some of his cases on Dateline 2020. Look up the spray tan murders. He's bringing that experience. He's also written eloquently from the bench on issues such as generative AI, collections of e-discovery. Please join us in welcoming yet another Gator, the Honorable William Matthewman. Next is the Honorable Xavier Rodriguez, United States District Judge for the Western District of Texas. As you know, he is also an academic because he's got David Kilgore, who was his teaching assistant in law school. He also brings unique experience in that he has been both a state and a federal judge. He was on the Texas Supreme Court. He's now a federal district judge. He writes extensively. He's got a law review article that's associated with this conference. Please join us in welcoming the Honorable Xavier Rodriguez. The Honorable Julie Sneed went to law school at Florida State. However, she is a graduate of the University of Florida. She will always be a Gator to us. She has been on the bench. There's an fairness to the Knowles. We're all siblings here in this wonderful state. Judge Sneed has been on the bench for over a decade. She was first a United States Magistrate Judge. She's now a United States District Judge. And she brings the experience also from litigation, being a partner at 2 law firms. Please join us in welcoming the Honorable Julie Sneed. And our newest member of the panel is the Honorable Danielle Taylor. She also brings state court experience because she is a civil court judge in Jefferson Parish, which is just outside New Orleans. And she brings experience having been a paralegal before going to law school. Paralegal is an extremely important part of the e-discovery process. She also practiced family law, criminal law, personal injury before ascending to the bench. Please join us in welcoming the Honorable Danielle Taylor. All right, here are our topics today, and you are going to be involved in this, just like in that last excellent panel where we saw real-life arguments back and forth. We've got Dean Mazerat here, who is going to be manning our polling data. And what we're going to try to do, we don't want to sit around humdiddy waiting for poll results, but if Dean can get us good results in about 30 seconds, we're going to use that to set the stage for the discussion. You can see our topics. And unlike what Scott Milner says, we are going to talk about AI in this session, and we're going to find out some of the ways that the judges are using it. We go on to judges in data protection, the work product doctrine, it's e-discovery, you can't go without that. We'll get back to AI hallucinations toward the end, and then finally, this all comes together. You saw in the description, we're going to talk about robots and rules, and do they need amending? All right, the judges in artificial intelligence. First poll question. Have you ever used generative AI in your legal practice? And this is a simple one, yes or no. And one of the reasons behind this is that we have done studies at Relativity with IDC, with our Kaplan advisors, and this number has been increasing, not surprisingly, extensively since the release of ChatGPT in the fall of 2022. So have you ever used it? We're going to see if this trajectory continues. Dean, how are those numbers looking? All right, a sizable majority, which was very different. Changing on that one? More election results? You have to repeat the answers. Great, okay. I'm going to repeat those numbers because online does not be able to hear Dean right now. It was 67% yes and 33% no. So a sizable majority. Let's move on to number 2. And this one, by the way, before you answer, you are not discussing any of the 6 judges on this panel. This one is, do you believe, who's more proficient in artificial intelligence, judges or lawyers? And we have done these surveys over. We've never really compared judges before. Some of the data were, who's got greater technological efficiency? Is it paralegals? Is it lawyers? Paralegals are always coming in higher than lawyers on this one. So let's see how it goes here. Dean, any good data? 1288. So 12 are going with the judges and 88 with the lawyers. Very interesting.
12% of us judges.
Yeah, that would be it. And so it looks like the lawyers on this one. Now, let's be fair. I bet the audience is probably more 88% lawyers than judges, but we'll see how that works out. All right, so looking at these numbers, a question for you when we look at them. We'll start off with Judge Taylor. How much AI or technology do you use in your everyday practice? What's going on? And it doesn't have to be AI. Are there any advanced technologies that you're using?
Our clerk of court has a system called JeffNet. It actually was a program that was in-house written for us, and it digitized all of the filings. Probably 95 to 90.
Judge, can I ask you to, there's a little button on the top or the lavalier right there. You got it. Thanks.
All right.
Thanks, George.
I use a system called JeffNet, and probably 95% of all of the pleadings are filed electronically in my jurisdiction because our clerk of court and our basically judicial administrations made it that easy. So it goes into JeffNet, my clerk gets it, and then it gets sent into an e-basket, which is great because I literally can access my e-basket from my phone wherever I am. If I'm not in the building, they can call me and say, there's a pleading in your e-basket, can you look at it? I can sign it, deny it, I can add text box, I can strike through it. It has hyperlinks, which if I click on the case number, takes me back into JeffNet so I can review the record. There's something I want to review before I decide whether or not I'm going to sign it. I was astounded. I've been so spoiled by it. I was astounded that everybody doesn't have this. I figured out after traveling, they're like, you do what? And I think we're the only jurisdiction in Louisiana that has the e-signing that works this fluidly with our e-filing system. We've also started using something called the Record Exchange, or TRX, which I don't know if anybody's familiar with that, and it is audio files of all of my hearings, and it uses AI. So if I say, you know what, I had that issue, what was the case I had it? I can go and search in the last 6 months, in the last year, and then it will find the hearing where I discussed that, and I can actually say, okay, what were the cases, and go pull them again. But what's really great is if you ask it for a summary of that hearing, what issues were decided, what were the things in contest, and what was the ultimate decision, it's scary how accurate AI is. Like it is, I tried it first time on a succession, and what were the assets in contest? It named every one of them. Who was going to be the executor, whether the house would be sold, that there were disputes over the ownership of certain bank accounts. I mean, AI went through that recording and summarized that hearing for me.
A success story with AI. We love hearing those. Going on to Judge Sneed. You and Judge Barksdale and I have discussed in the past how you've got robust local rules in the Middle District. Are there any guardrails you put on the use of AI, or how do you use AI in the Middle District?
We do use AI in the Middle District. I do think we are very forward thinking in terms of technology in general. We use AI in terms of Grammarly. There's a program that adds a few more commas, tells you a better way to write emails. I'm not using it so much with the written orders, but it is very helpful. I'm going to throw back to Westlaw and Lexis. That is a form of AI. I'm counting that as well. We also, I admit that I was freaked out. I'm going to use that terminology. I was freaked out when in the news, it was reported that 2 judges' orders were drafted using hallucinations or citations that just did not exist. I mean, we've heard it from the lawyers, but it is just, it's just, the last thing you want to hear about. You hear a judge in the United States citing hallucinated cases in their orders. And so I checked with our IT committee. Judge Barksdale is on that committee. And we have this resource. You all are probably familiar with it through Westlaw and possibly Lexis as well, where you can load up your draft order. It is in a confidential system that says it deletes it before, once you use it, and it will check to be sure that you have no hallucinations. And so I like to use that to double check to be sure that there are no hallucinations. So we encourage it. We're also in the process of coming up with some new guidelines. I, for one, do not mind, of course, lawyers using AI to draft pleadings. I think you should use all the tools and resources that you have available, use them. But, once you have those cases, I think it's better to rely on Westlaw or Lexis personally. But if you are going to use it to find cases, then you do need to take that brief and then run it through some sort of citation check just to be sure that you are citing cases accurately. And I'm not convinced that we need otherwise new rules to tell us that rule.
That's foreshadowing of what's to come later in this hour. Thank you, Judge Sneed. Judge Rodriguez, you've written eloquently on the use of AI in the law, spoken at Sedona. You've got our law review articles on the subject. What about what you're doing in San Antonio?
Yeah, so I want to piggyback off Judge Sneed's last comment, though. This is where in the judiciary, we are not singing off the same sheet. So the ethics committee issued out these guidelines or advisory a couple of weeks ago, and it says not to do what Judge Sneed just recommended, which I agree with. To ensure that none of us are making mistakes with hallucinated cases, we ought to be running our briefs through a Westlaw or a Lexis or a similar program to ensure that those cases accurately are citing and existing. And we as judges should be doing that. And our ethics folks said, oh no, security concerns and this and that. I called up and I tried to explain to them, guys, this is at the end of the process. This is before it's going to the clerk's office. It's going to be immediately published thereafter. So we got a lot of work to do within the judiciary. We are a long way from understanding a lot of these tools. And so what am I doing? I'm going rogue. And so I'm playing around with 9 different products. I'm using what I call, and I think I heard the term earlier today, high value, low risk. I use it for preparation of hearings. I do chronologies. I do summaries, all for me to be better prepared during either your Rule 16 conference with the court or a motion hearing, for me to ask more intelligent questions of you, to have an understanding of your positions. And again, this is the high value, low risk, because I'm not using it to make any determinative decisions. I'm using it to have a further engagement with you during the hearing. And so that's what I'm doing, but that's hardly, we're all over the board as judges.
Judge Matthewman, how about in the Southern District?
Well, you know, I tell my law clerks, I said, I don't mind if I get reversed on my reasoning by the 11th Circuit or a higher court, but don't let me get reversed because we cite a fake case or we miscite the holding of a case. And I tell my law clerks that all the time, and the interns who come in. We use co-counsel on Westlaw, find that to be effective. We use Quick Check on Westlaw. We use Grammarly. But again, this is to assist. It doesn't make the decision. I make the decision. It just helps the product and make sure that it's accurate, that there's no hallucinated cases, that the sites are all correct, that everything is accurate. So I think there is certainly a place for AI on the bench. And I think that efforts to restrict it are somewhat misguided. I do. I think it has to be just like with lawyers. Lawyers, I think, should use it also. I read an article recently where I think it was Judge Furman up in New York. He said he can envision that a lawyer not using AI might be committing malpractice. And there's issues that are going to come up about attorney's fees. If lawyers bill all this time, the other side may come in and say, well, you know what? They could have done it in a third of the time if they would have used AI. So why should they get all these attorney's fees? So, you know, I think that AI is here to stay. I think it's important. I think it can assist the bench as long as we understand it is not making any decision. We are making the decision. It is just helping us provide a better product in our orders.
Thanks, Judge. Judge Jones.
You know, I'll follow up on what Judge Rodriguez said, that judges in general are about 4 or 5 steps behind where the world is with technology. Judges are very cautious. The AO just came out with policies, a lot of which makes sense. You know, when you're a judge and you are making a decision, you're supposed to make the decision based on the information submitted in court, in the briefs. You're not supposed to do your own research. So it's very tempting as a judge to jump on AI and find information that might cross ethical guidelines in doing that. So I don't use AI at all for anything with regard to decision making. I do use AI very frequently in my personal life. I teach a constitutional law course. I use it for PowerPoints, hypothetical questions, questions I'll use on examinations. I certainly don't rely on it verbatim, but it's a good starting point for drafting. As a judge, where I actually have used AI, I do settlement conferences, and usually you get a brief from each side telling you what the issues are so you get up to speed on it. But it's very beneficial when you are acting as a mediator in a case to really know as much as you can about the case. So what I'll do is I'll use AI to summarize. If there's a lengthy motion for summary judgment, maybe depositions, all this information is public record. I don't take private information and put it on there. And it can use that to get me up to speed. The other thing I find AI is really very helpful for in a settlement conference, or this would apply to a hearing, having AI analyze the information in the case file and suggest to you some potential questions you might ask as a judge at a hearing. And amazingly, AI can really offer some really good questions, maybe things you haven't thought about. There's a law firm in Chicago, I forget the name of it, very large law firm, and they've developed their own internal AI, I guess you call it a RAG. And in their appellate department, they use it to prepare for oral arguments. And they put all the briefs, all the information in, and have the AI generate potential questions that they're going to receive from the bench, and they use that in their preparation for oral argument. And one of the lawyers from this firm was telling me that the last time he had done it, AI generated 10 very good questions, and 7 of those questions, almost verbatim, were actually asked by the appellate panel. So it can be very useful that way. Lastly, a way I don't use AI, which I would like to use AI more, one of the things I do, I help out in the Southern District of New York, and I do a lot of Social Security appeals. Doesn't sound very interesting. It's actually not real dynamic area of the law, but it's very document intensive. And I would love to be able to use AI to summarize the medical evidence, to create a timeline, because all of that's very important for the decision making. As judges right now, our hands are really tied. You know, we have court computers, and there's just so much we can use that's authorized for judges to use. But hopefully, in the coming years, we're going to get ahead of it and get in step with where AI is really going.
Thanks, Judge. Judge Barksdale, the view from the Technology Committee.
Well, I use AI in my personal life. Really, it's just so I can understand it and not be afraid of it. In the workplace, never for deciding, sometimes for writing through Grammarly, which suggests restructuring sentences and such. Sometimes I accept the suggestions, sometimes I don't. I think if I accepted all of them, my writing would be even more wooden than it already is. For researching, I use it a lot using co-counsel. The policies that were referenced by my colleagues here, I call them the 10 commandments of AI usage in the judiciary. In order to get co-counsel, a judge has to sign an agreement that they'll comply with the 10 commandments. There are things like you have to use AI tools in a way that won't undermine the public confidence in the judiciary. You must not use AI to substitute your own decision making. And then one of them, I think Judge Rodriguez doesn't like this one, I could tell, which is when using covered AI tools, users must only input information that the judiciary has already made publicly available.
It is already publicly available. When you all file something and it's not sealed, it is publicly available. We are not ingesting anything else. I don't understand what these people are doing.
But I did not write the 10 commandments. But the co-counsel has been really helpful both in AI-assisted research, but in parallel search, in submitting publicly available documents to create timelines. Things like that. I found it very, very useful and really enjoy using it. I will say the federal judiciary is not as old and dusty as you might think. We do have an AI working group at a national level with really, really knowledgeable people and judges on there from all different types of areas in the judiciary. They're working hard to try to figure out how the judiciary is going to use AI. Last thing, I'm on the case management board at the national level, which is taking things like PACER and our internal CM-ECF and completely revamping that. In the process, we are looking at AI tools to make our organizational life easier.
Thanks, Judge. We are going on to a new topic. Yes, Judge Artigler.
We have some interest online in this question. How do you feel, judges, how do you feel about litigants using AI tools that have learned your specific preferences and auto-drafting content that predicts what you specifically would be more responsive or willing to do?
Who would like to touch that one?
If I was a lawyer, I would do it. Why not? Obviously, if that's all you're going to rely on, you better go back to law school. But that gives you an edge. Certainly, if you present a case to the Supreme Court or to a court of appeals, you're going to look at who's on the panel, how they've decided, what issues have been important to them. So if AI can help you get an insight,
and I'll just say, good luck on that prediction, because I've been out to dinner with a lot of judges, and sometimes they can't even decide what to eat for dinner. So all I can say is try it if you want to, but don't rely too much on it.
Thank you, judges. All right, we're going to move on to a non-AI topic. It could be an AI topic, but this one is more old school discovery. This is judges and data protection. How should litigants be sanctioned if they send malware in their productions. And so, Dean, we've got a poll coming up. And should litigants be sanctioned if they send malware in their productions? A, severe sanctions no matter what. Data protection and cybersecurity are important. Throw the book at them. Or B, no sanctions are limited unless gross negligence is shown. If there are no serious spoliation sanctions for no intent to deprive, what about no intent to infect? All right, and we'll let people comment on that over the next 30 seconds. Surprisingly, the reason this came up is we're going to discuss a case, and I sort of stumbled upon it, and I am surprised by the lack of jurisprudence on this issue. There is just not much. Dean, what do we have? 27 on A, severe sanctions no matter what. And so we're showing a little bit of grace in these situations, it would appear, at least from the people attending. All right, and what brought this case up is sanctions for malware and e-discovery, and believe it or not, that is an AI-generated image. And this case, unfortunately, the court didn't decide this issue in the case, but it brought up an interesting issue. So it took a spin through the case law, and there's just not a whole lot on it. The issue wasn't decided here, but it brings up the issue. What happens if you give a production and it's got malware in it? And for this possible quasi case of semi-first impression, Judge Barksdale.
At the outset, I'd like to register a complaint, David.
Yes.
So David prepares us extensively for this panel. He sends us cases, he sends us articles. This particular case was 44 very cumbersome pages. I diligently read it because I do my homework. The sentence about malware is literally one sentence in footnote 1. That was it.
Exactly.
And the judge doesn't decide it. They say, I think the party wants me to sanction for submitting discovery with malware, but they didn't raise it during discovery, so I'm not going to decide it. So thanks, David. But
when you see me in the Duval County Jail tonight for contempt of court, you'll know why.
But I did look at the underlying documents. This is an interesting case because it's alleged that the person sending the discovery did it on purpose. And so that's naughty. Don't do that, right? If it's on purpose, maximum sanctions are at play, of course. It's really a tort within a lawsuit, right? And it maybe could be brought as a separate tort. If it's unintentional or just negligent, certainly I think ordering the costs of what it took the other party to fix, what happened certainly would be in order. A question would be whether comparative negligence principles apply. If you're the recipient of the discovery, aren't you doing something about that? Aren't you making sure it's safe to open in your own computer system? And in this case, the recipient actually did figure it out before it caused any damage. It was a Trojan virus. And the plaintiff in this case, Future Field, said something like, this is what we do. Of course we discovered it, but we knew it was intentional.
Judge Jones, what if it's not intentional?
Well, let me just say, it's interesting we're talking about this. So I've been on the bench for 27 years. I've never even thought something like this would happen. But in today's current legal climate, pro se parties use AI now. It's not a fantasy that this is going to happen. My view is, first, if you were to do it intentionally, it's a violation of federal law. There's a statute, 18 U.S.C. 1030, makes it a felony to intentionally transmit code that causes damage. You can sue civilly for damages. So the sanctions, apart from what the court would do, are pretty severe. But from the court's perspective as to whether, if I was faced with this, whether I would impose sanctions, and if so, what kind of sanctions, it really depends on the circumstances. If it was intentional, I think the full play of sanctions would be available, entry of default judgment, costs, attorney's fees, referral for professional disciplinary action, all of that would clearly be warranted. Quite frankly, I can't think of anything worse than someone intentionally doing that. If, however, the transmission was negligent, then I think you're looking at the cost of data repair or recovery if indeed.
Under what rule would you levy sanctions for negligence?
Inherent authority. But it raises an interesting question. I just throw this out, whether there is an obligation of the requesting party who's receiving production to screen data before loading it on your system for review. Just like there's an obligation when you produce your data to the other side, they have an obligation to keep it confidential, not loaded into a consumer version of AI. Is there an obligation when you're getting documents to do some kind of screening to see if there's malware on it? I don't know, but it's something certainly to think about.
Judge Matthewman, your take on it.
Well, I think if the parties are using a reputable ESI vendor expert like many of the folks in this room, it's not going to happen, number one. Number two, I've never seen it happen in many years on the bench. But on the other hand, I can understand how it could happen inadvertently, because let's face it, companies and businesses and banks and all types of companies are infected with malware all the time. And it's led to a lot of losses financially. So I think it has to be, in the pro se cases, I think receiving parties should be very careful. And I think in cases where the lawyer is not using an ESI expert or ESI vendor, I think the receiving party should be very careful. But if it's inadvertent, I really don't see any sanctions at all. If it's purposeful or reckless, that's a different story. But if it's inadvertent and somehow there was a virus, a malware in the production, I don't see sanctions being appropriate at all.
Thanks, Judge. Judge Rodriguez.
Yeah, so I also distinguish between intentional conduct and negligence. And so when under intentional conduct, you probably can get sanctions under 26G, you probably can get sanctions under Rule 11, you probably can get sanctions under inherent authority. But for negligence, even under inherent authority, I don't see how a court can sanction.
Judge Sneed. Thanks, Judge Rodriguez.
In considering this issue, I think it's interesting about whether or not, it is intentional or not intentional. I see that as a huge issue and something that is going to really be the source of a lot of litigation. I don't know who's going to admit that it was intentional. And so I think that, that's going to be a source of a lot of inquiry. And I'm really going to want to get to the bottom of it. There's going to need to be some experts, bring in the technical people, because if someone intentionally put malware on discovery, I think that erodes their reputation. I think it seriously needs to be punished. I think it's unethical. It's going to interfere with their reputation and their professionalism within the court. So if it was intentional, I'm going to really want to drill down to the bottom of it, and there are going to be sanctions. And I don't like to impose sanctions, but if it is found to be intentional, that's a huge problem.
Thanks, Judge. Judge Taylor.
Well, I would agree with Judge Matthewman, and the whole inherent authority, because in Louisiana, in our broad concepts of civil law, everything that says every act whatsoever a man causes damage to another is bound by whose fault it happened to repair it. That's the rule. I think I could invoke that rule when we're talking about sanctions and having to repair something as a result of someone's negligence. We also have another article about sanctions that says that if every time you sign a pleading, you're warranting certain things to the court. So even though it was negligible, even if it was negligible, if you're warranting that and it turns out not to be true, you can be sanctioned. And obviously, if it's purposeful under that same article, you can be sanctioned. So for my purposes in Louisiana, I wouldn't have any problem addressing it in both of those veins.
Thank you, Judge. Let's move on to our next topic. And this one is a topic that's been discussed a lot lately, and it was discussed this morning. And I failed in trying to get Judge Rodriguez to kick us off early in the excellent panel that he had with Kelly and Maria this morning. But here's our poll question, and that is, Should artificial intelligence prompts be protected by the work product doctrine? Notice we're not talking about the attorney-client privilege. We're talking about the work product doctrine. And you've got two options, most likely yes, most likely no. And there is your nota bene, that is lawyer's answer, if it depends, is not available to you in this poll. So we're trying to shoehorn the data a little bit. And Dean, how are our results coming in? That is 83. Most likely, yes, it is protected, and a very small percentage not protected. Judge Sneed, you get to kick us off on this one. How do you come down on it?
Yeah, so I would say so it depends. First of all,
you get to say that.
First of all,
you
it depends. It does need to be prepared by an attorney in anticipation for litigation. So there's a lot in that. So was the prompt done by an attorney, and was it done in anticipation of litigation? One of the cases that you sent to us, David, with the ample preparation material that you gave us, sort of talked about this topic. And in that particular case, an individual was thinking about, did I commit a crime? Did I commit a crime? And so we was sort of doing some investigation about that topic, and to put in the prompt about what sort of defenses he could raise. And you could see the same situation occurring about whether there was a breach of contract or not. Well, if you are an individual you're putting these prompts into the AI search engine, and you're not doing it, you're not an attorney, and you're not doing it in anticipation of litigation or at the direction of your lawyer, then I'm going to say the poll question would be most likely no. Also, there is a difference in attorney work product, a work product doctrine, whether it is an opinion issue or whether it's factual information. And we know that opinions are a lot more protected than facts, and so facts might be available. I also want to tell you that I was curious about what ChatGPT would say about this topic, and ChatGPT, when I opened it, it said, beware, AI prompts are not confidential. That was the first thing it said. And it said that the prompts, in fact, are used to train the AI so that it will produce better responses. But after that disclaimer, I had to print it out because I wanted to make sure that I could access it for you all. ChatGPT did say that it can be attorney work product, but not automatically. It also said it depends.
Thank you, Judge Sneed. Yes, we've got one from the audience. We have Kelly Twigger.
Thank you, Judge. I am curious if you change the analysis to a point where you're using a confidential version where the prompts are not used to train the model. If you've perhaps created a custom GPT, or you've engaged even in a team plan on a chat on OpenAI, the different tools have different levels. How does that change your analysis?
Well, I think you still have to go back to the basic law about whether it was done by an attorney, right, in anticipation of litigation. So, and if you are able to add those facts that you just mentioned, that it was in a closed source, that this was confidential, it would strengthen your argument. I'm not going to give you a blanket ruling just in case this comes up in court, but I think it would certainly strengthen your argument.
Okay. Thanks, Judge. At the risk of seeming that I am lobbying for my employer, I think that everyone agrees that you want to use a tool that is expressly designed for legal work. You would not go out and go buy something off the shelf. There are many fine consumer products, but this is probably not where you want a consumer product. You will probably want a legal product. On to Judge Rodriguez. How do you come down?
So you heard my comments earlier in the day. Let me spin it to something else. So, a whole bunch of groups have been trying to work on access to justice issues. I think this is going to have a huge impact on that. If we're telling unrepresented parties that their investigative aspects into their case, either criminal or civil, is not going to get any protection, then I think the use of AI tools as an adjunct to nonprofit providers, then that just all goes away. And so again, I think we need to make a distinction, right? If you're using an AI tool just like you used Google in the old internet day, God, we already make it seem like that was an age past, right? If you're using it for nefarious activities, well, then, that's not protected under anything. But once you have reasonably anticipated litigation and you're unrepresented, I mean, I don't know how we're ever going to have access to justice augmented by this stuff.
Thanks, Judge. Judge Matthewman.
So I agree with both Judge Sneed and Judge Rodriguez. I go on the side of A, most likely yes, but again, it does depend on the facts. I do think there's a cautionary tale here for counsel. If you're a criminal defense lawyer and your client is out there outside of your supervision doing these prompts, you could end up having a problem down the road if it gets discovered. Likewise, if you're a prosecutor, an agent doing these prompts could be somehow discoverable. So I think you'd have to be very, very cautious. I think if the private investigator does it, it's more protected. If the lawyer does it, it's more protected. But it is a difficult issue because I do believe that AI has a beneficial effect of being able to assist pro se parties in litigation and poor parties in litigation. And so I think that has to be given some consideration because we get a lot of pro se cases, and some of them are, terribly written, hard to understand, hard to decipher. I would probably rather that the pro se litigant use some form of AI, do some investigation on their own to try and make a better presentation to the court. So I do lean on the side of protecting it as much as possible when the facts and law allow.
And tell you what, before we get to you, Judge Jones, we've got an online question.
Yeah, the online question has to do with the pro se issue just raised by Judge Matthewman, and maybe the state court judge could address it. On our various Florida bar committees that many of us serve on, there's been I won't say a panic, but there's been a concern by state court judges that they're going to be inundated with briefs now. So it's a paradox. We want more access to justice, but at the same time, the state court judges especially are really feeling they're going to be overly burdened by the volume of pleadings they're going to be facing, the number of cases are going to go up. And I was wondering how you all want to respond to that, especially most of you are on the federal bench. I think it's the state court bench is more of a critical problem.
Well, most of the time they don't know when they're supposed to file it. They show up, they'll show up in hand, and I'm like, yeah, local rules say you're supposed to file that 8 days before this hearing. So unfortunately, like we're seeing it in practice, but it's not perfected because AI isn't telling them you need to file it 8 days before the hearing. So that's one of the big problems on the criminal side, because I do civil and criminal. I've had some sovereign citizens, and they're probably my biggest offenders when it comes to that, because I'll get a stack of gibberish is what I'm going to call it. But I get a stack of gibberish about that. I will say our court is also using some AI technology to assist our pro se litigants in domestic, because the National Center for State Courts has started a program called Right Start, Right Time. It's going to create a dashboard and a questionnaire, and it's going to upload like drafted forms and allow our domestic litigants to get into that system, answer this questionnaire, and it will generate their own child support, petitions for divorce, pleadings for them. So we're going to be using AI to help them on that front, but we don't have anything to help the other guys. I've had lawyers use ChatGPT with some fake sites. I've had a couple do that, but in our parish, but I haven't had that particular issue yet. I'm waiting for it. I'll brace myself.
Thanks, Judge.
David.
Sure thing.
Given what you just spoke about with the pro se litigants and access to justice issues, and along with the recent court rulings, do you think the work product doctrine would be sufficient to protect those litigants, or should there be a privilege exception that is expanded just in a limited instance for the pro ses and indigents that need to maybe access these AI platforms?
Judge Rodriguez, you hit on that somewhat this morning. Do you want to delve into that one, or anyone else want to jump on that one? Sure, please. Yes, Judge Barksdale.
You know, the case we were talking about earlier involves Mr. Hepner. That's a criminal case, and I think it's really important to remember that. How many criminal practitioners are there? Most of you are civil practitioners. Use Hepner at your own risk, because that involved documents that were seized during a search warrant. And so if they had been produced during discovery, then Federal Rule of Criminal Procedure 16 would say they're protected even though they were produced by the defendant. So because it was a search warrant-based case, the judge fell back on Hickman versus Taylor. We're in law school. I just said Hickman versus Taylor. Isn't that great? You know, that Hickman versus Taylor says it has to be produced by the lawyer, and that was the basis for that decision. In the Federal Rules of Civil Procedure, and I think most states are the same way, it does not have to be produced by a lawyer to be protected by work product. Rule 26B3 expanded Hickman to say work product will protect something made by the party as well. Keep in mind also that 26B3 relates to documents and tangible items. So I wonder, what you input into Claude, is that a document or a tangible item? I mean, it's something to think about, because only documents and tangible items would be protected, right?
You know how odd that is, though. You know, so okay, if you actually type a prompt under that theory, that's not protected. But if you put it into a piece of paper and then upload it, that would get protected.
Oh, interesting. Judge Jones, if you could take this one. I thought the question that Bill gave us from online was an interesting one. And, you know, Bill mentioned this morning the law review articles that are associated with e-discovery. I had the honor of joining our lead author, Judge Ralph Artiglaire and Rose Hunter-Jones, and we were going back and forth on the effect of AI, and one of the issues came up was that very question, whether or not you are going to have a flood of paper, and is it an interest of judicial economy to do something about it, and then what can you do?
Yeah, I don't think that's going to happen. I actually think pro se parties using AI would increase the quality of their filings. So it may benefit the judiciary. But I don't think people are just going to go out there. There's some crazy people that file stuff, but they are really the minority. Where you have a pro se party who feels they've been wronged, I think AI levels the playing field a little bit if they don't have a lawyer. Now, as to work product, if I would pick, it depends. But if I had to pick door A or door B, I am going to side with prompts being work product. And, you know, as a matter of policy, it would really have a chilling effect on litigation if prompts were not presumptively protected as work product. If that was the case, people would stop using AI. Subject, of course, to the following exception. You know, we talk about AI, that's a generic term. If the AI you use ensures that the AI retains your prompt, your data, your output only in the client tenant, and it's not being used to train the LLM, that's fine. If it crosses that line, then I think the work product privilege doesn't apply. It's been waived. It's no different from a party putting a tweet out on the internet. So subject to that exception, I think prompts are presumptively work product.
Thanks. And to Judge Barksdale.
Can I go back to Bill's question
Of course
on
you can.
pro se litigants?
Yeah.
Empirically speaking, I have noticed a difference, and it is a problem. You know, when we have a pro se pleading, we want factual allegations that state a plausible claim. We don't care if they cite the correct statute or the correct law. It's what are the facts that you're alleging, and does it state a claim that's plausible? I'm seeing fewer factual allegations and more pages of just law in the pleadings. So it's a problem. And we have to read all of those pages. You know, we might get a 25-page pleading with 2 or 3 factual allegations, and the rest is AI-generated law.
And then you have those moderators dumping case law on you. Sorry about that.
And then there's that. So I'm not sure how to address that, really. What do? You can't just ignore all of those pages in the pleading because you're trying to figure out whether it states a plausible claim. But it is a problem.
Thanks, Judge. Before we leave this topic, Judge Taylor, would you like to weigh in?
Well, I think, I said what I was going to say. I said all of that earlier, which was I've had lawyers use ChatGPT with some, and it's kind of made in more than one of the courts, and it was the same offender, so shame on them. I haven't had a whole lot of pro se litigants that are using ChatGPT. And what's interesting, usually what I get are factual allegations that aren't enough. I haven't yet gotten what you're talking about, which is all of the law and no factual allegations. At least not in my jurisdiction. I haven't been experiencing that. I probably get more of it, not in civil, but in criminal pro se, believe it or not, as opposed to civil. I think I see more stuff that looks like it might have come out of ChatGPT when someone decides to draft their criminal motions or their own criminal motions.
Thanks,
David,
Judge.
can I chime in on this?
Sure thing.
This is an e-discovery conference, right? So I think where we're really going to start seeing this question being raised is when you all are starting to use AI e-discovery products, and then you're going to want to have the other side explain to you which product did you use, how was it trained, what were the prompts put into the query, and this is where we're going to see this. And so, and you know, in the old days, I try to compare to the old days to the current because I think that should inform how we're operating here. In the old days, if someone went out and got a group of young associates and said, okay, this is what this case is about, copy, copy, copy of complaints. This is the request for productions, copy, 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 copy. This is my own internal work product of what we think is the important issues of the case, the players, the relevant dates, copy, 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 and then we would go to the warehouse and pull stuff. And that was always considered work product. The training, that's going to now be part of the training set into the AI discovery tool. And so I think this is going to be the next horizon for a fight.
Thanks, Judge.
I think people are going to expect to be cautioned about what's going to be work product and they're going to be looking at us to tell them is, well, are you going to call that my work product or are you going to call it not my work product? And I think the question that was asked was, what kind of protection are you going to extend to a pro se litigant? I don't know that the law really says that the pro se litigant's thoughts and impressions are protected, whereas an attorney's are. And I think we still have that problem when we're talking about AI.
Right.
Yeah, I was changing the hypo, but yeah.
Yeah.
On to our next topic. We're going to go back to sanctions, not malware sanctions, but sanctions that you've heard ad nauseum, hallucination sanctions. And so we've got a poll question. And that one is, how severe should the sanctions be submitting AI hallucinations to the court? Nominal sanctions only, stop the madness, the hysteria's gone too far. Most judges don't refer lawyers to the bar for misstating the holding. And by the way, you can be casting your ballots as we read these out. So you've got nominal sanctions only, serious sanctions of gross negligence, or serious sanctions in almost all cases. Throw the book at them. They should cite check before they certify their filings. Dean, how are our poll results looking? 11%, 46%, 43%. That's 11% for nominal, 46% serious of gross negligence, and 43. All right. So we've got an even split on those sanctions for if you get more serious. And so we're going to see how the courts have handled that quickly. First of all, this is an interesting case from South Africa that Linda Sheehan from ENS brought us at Relativity Fest on the international panel. And it's bolded on the bottom for a reason. And the court's opinion there was, in this case, almost beat out MATA as the first known case. But look at that bold part. The embarrassment associated with the incident is probably sufficient punishment for the plaintiff's attorneys. Then we go on to another case that's sort of on one end of the spectrum. This is Tiffany K v. Commissioner, a recent case from January. And as you can see, it's a litigant that is going forward, represented by counsel, but it was only a warning. Now, in fairness to the court, warning was in all bold, all caps. But then it was only in a footnote, like we had before, and it was in the same breath as, well, you violated the thing on 14-point font, too. Judge Jones, you get the first crack at this one. How do you think sanctions should come down?
Well, sanctions, we saw the panel on sanctions before. These hallucinated cases are a big deal. I think he's cited statistics. There were almost 1,000 reported cases, probably more like just in the United States, about 275, 300 cases, but it is an issue. And, my view is, the penalty should be equal to the crime. And that what a lot of judges focus on, and I'm not being critical of other judges, but what they focus on is only the harm side of things. They look at the time and money the opposing party wastes, the court's loss of time, the client being deprived of relevant arguments, harm to the reputation of the judges and names who were associated with the fake citations. It promotes cynicism about the legal profession. And future litigants, may be tempted to defy judicial rulings claiming doubt about authenticity. These are fake decisions. All of those things are certainly important considerations, but I think you have to look at the conduct first and balance. You have to be proportional and balance the conduct with the harm. So, for example, if there was one miscitation in a brief on a collateral principle of law, that might require a footnote by the court. That's not something many judges are really going to lose sleep over. If, on the other hand, you had a mass of MDL and one of the issues was whether a certain jurisdiction had comparative negligence or contributory negligence, and there were fake citations, the wrong representation of the law on a critical issue, then that might be a situation for more severe sanctions. About making mistakes, I always say to my law clerks when they start, I give them a little orientation. I always pull out a pencil and I show them that my pencils have an eraser on it. And I say, we all make mistakes. No one is infallible. And I think when you look at hallucinations, judges have to balance and use proportionality principles in determining what would be appropriate sanctions. And if you don't do that and you just focus on the harm and you don't look at the conduct, what caused it, I don't think that's really an appropriate analysis. And lastly, I would say one of the things judges do look at if you do make a mistake and there is a hallucination in a brief that's filed with the court, don't hide it. You have to be contrite. Come clean. And where you see cases where there are severe sanctions, it's where lawyers try to blame someone else, throw someone else under the bus. Oh, it was that stupid associate I hired that did it. I rely on him or her. So I think it's very important to be contrite, and when faced with a situation where there has been a hallucinated citation in a brief to the court, come up with solutions and be able to present the court with safeguards that you are going to put in place so that won't happen again, because that's important to judges. They don't want it to be a continuing course of conduct.
Thanks, Judge. Judge Jones brings up an excellent point on the proliferation of these cases. And if you were able to join us yesterday when we kicked things off on the Relativity and International Legal Technology Association Year in Review, Scott Milner was with us, Maribeth Banashek, thank you again, was with us, and Judge Michelle Rick. And there was a tool that all of us use a lot, and that is Damien Charlaton's database of hallucinated cases. It's a great resource. He's a French researcher. He does a lot of work on this. If you're interested in this issue, I encourage you to look it up. And before we were getting ready for the webinar yesterday, I'm like, all right, we're checking, and our AI-generated graphic is, will we hit 1,000? Yesterday it was 973. I just checked it now. 978. So 5 additional decisions in one day. So that just shows you how this is going. But check out Damian Charlatton's database. It's really helpful.
Can I comment on that database?
Oh, no.
You know, so it's interesting, right? What I like about that database is it has an identification of which, if it's noted in the opinion or the order, which AI tool was used. I think that's very helpful because, you know, if we're talking about ChatGPT version 2.5 and everybody's going berserk about that, that's not the world we're living in right now. And then so that database ended up showing a couple of co-counsel cases. That's more interesting to me. If Westlaw and Lexis has got some issues, I would like to know about that. But, you know, we keep fixating on this 970, whatever it is. What the other side of the equation, which no one's keeping track of, is how many times have lawyers used used an AI tool correctly, verified the output, it saved time and money to the client. No one's keeping track of that side of the equation. We just keep fixating on this.
Great point, Judge. Thank you. Judge Barksdale.
In thinking about the question about sanctions, of course, it's going to depend on the circumstances. You hate that answer, I know. But it dawned on me that what Judge Sneed and Judge Rodriguez consider in sentencing at criminal cases under 18 U.S.C. 3553A might be a nice template for deciding this, so that practitioners asking for sanctions or responding to sanctions motions might consider that statute and just put it in the context of this. So it's based on the 4 punishment principles: retribution, deterrence, incapacitation, and rehabilitation. And so what we're considering in sentencing, which you could consider in punishment here for using hallucinated cases, nature and circumstances of the offense. What happened? History and characteristics of the defendant. Here it would be the lawyer. Have they done this before? Or do they have a stellar reputation in the legal community? The need for the sentence imposed, the punishment, to reflect the seriousness of the offense, promote respect for the law, provide just punishment for the offense, afford adequate deterrence, generally and specifically. That's a huge one. We want to deter lawyers, and that's what we've been doing for the most part. Provide the defendant with needed correctional treatment, medical care, and educational. That's in the sentencing context. In this context, can we make the person who cited these cases attend this e-discovery conference and write an essay about it? Or how are we going to rehabilitate them? How are we going to train them so they don't do that in the future? The kinds of sentences that are available. What are the types of sanctions? There's monetary, there's educational, there's volunteering. There's so many different things that we can bring to the table, and we should, in order to be creative and address the specific problem before us. Pertinent policy statements. What are the policy statements out there that the judiciary wants us to apply? The need to avoid unwarranted disparities. That's a big one. We want to be even in the judiciary. We don't want one judge throwing the book, your next slide is throwing the book, and one giving a tap on the wrist. That's a disparity we want to try to avoid. And finally, the need to provide restitution to a victim in the sentencing context can apply here. The need to address what the other side, the cost to the other side. So I'm kind of liking that as a template for this.
Thanks for the template. Judge Taylor, you see throwing the book here in Johnson v. Dunn. How do you come down here?
Well, when we talked about Johnson v. Dunn, I think we talked about that when we were preparing for this. At first I thought, gee, that I wanted to know, like, is this the only time? I want to know all the things that she just talked about. Like, can I have all the backstory to it before I decide, should we throw the book at someone? I told you, we have a multiple offender in my jurisdiction, and then I just heard that there is now same offender in the appellate court. So they obviously are not learning anything. I'm waiting for the book to be thrown in that one. I think it's going to happen. And I think also we need, I know we're going to get to that topic about what should be the rules for using AI, and do we eventually adopt rules on how you use AI?
Right.
And I would tell you that my personal belief is that AI is kind of like medicine. And if you use it as prescribed, you're probably going to be okay. If you go off script, as they would say, then you're probably not going to be okay.
The off-script doctrine, very appropriate here. Before we move on this one, we're a little bit pressed for time. 2 housekeeping things. Number 1, our time is till 5:20, correct? Correct. We know there's a reception waiting for you, but we've got some great stuff coming up. Secondly, because lawyers get paid to be paranoid, we do not need a CLE code word in any jurisdiction where we're applying, correct? Okay, tell you what, in case we do, your CLE code word given to you at 5:05 p.m. Eastern Daylight Time is orange. Go Gators. It is orange.
Orange.
Let me
Please
weigh
jump in.
Before we do change the subject, in keeping with Judge Barksdale's analysis, I want to add in as a sentencing issue, we do think about what is sufficient but not greater than necessary. So I think that is on theme here. And also under Rule 11, that discusses sanctions, it does explain that sanctions imposed must be limited to what suffices to deter repetition of the conduct. So we really are thinking about the deterrence factor. In some of the cases that were put on the slides, it's important to know that there are some severe sanctions out there. So in case you're looking for something to include in your brief to ask for when this happens to you, these are some excellent cases to think about. Revoking pro hac vice status, striking pleadings, notifying the client of this transgression, an apology letter to the judges who were miscited, notifying all of the judges in the cases that you have pending in general across all jurisdictions, and the clerk's office reporting the attorney to the State Bar Association for further proceedings, publishing the order of sanctions in the federal supplement, disqualifying the lawyer from the case in general. So these are some very severe sanctions. And so I think I would definitely want to consider what's sufficient but not greater than necessary, what's limited to deter future conduct, probably something more than just mere embarrassment, just for the sake of having had this happen, and probably more than costs imposed, but something a little more lenient than what might have been accomplished in these cases.
In the pre-AI world, I mean, lawyers misrepresented cases, didn't understand cases.
Before
they
AI.
said it stood for Proposition A, and everybody else in the room said, no, it's Proposition Z. People failed to identify relevant authority from the jurisdiction you're in. There was all these mistakes made, and there wasn't any reaction like this. I think we're going way overboard.
Judge Matthewman.
So David, I think I base it on the Goldilocks principle, Goldilocks and the Three Bears, because if you recall, Papa Bear's big bowl was too hot, Mama Bear's was too cold, her porridge, Baby Bear's was just right. And I think what you have to do in these cases is look at all the factors everybody has discussed and be just reasonable and proportional to what happened. And when you do that, I think you go to Baby Bear, just right porridge temperature, and you're not making it too hot and you're not making it too cold. Because if it's too hot, I think it's a problem, it's too excessive. If it's too light, just a slap on the wrist, sometimes that can lead to more of the same happening.
Thank you, Judge. By the way, before we leave this topic, 2 resources. You should check the case law. Judge Matthewman's not going to talk about it here, but he has eloquent case law out of the Southern District of Florida on this topic. I encourage you to read his opinions. Also, Judge Ralph Ardeglair, who's been a member of this panel before, has written with our leader, Professor Bill Hamilton, specifically on Johnson and some of those sanctions. Judge Matthewman's appeared on a webinar with them. So I encourage you to check out those resources, that case law, that webinar, and of course, the article with Judge Ardeglair and with Professor Hamilton. All right, last topic of the day, robots and rules. We're going to do this one quickly as we've taken all this down. You've got all this information. You've got these opinions. Should the rules be changed? Dean, we're only going to have 20 seconds on this one, and that is, should the state and federal rules be amended to address AI, including deepfakes? You've got yes, challenges posed by AI, including deepfakes, require new amendments to state and federal rules. No, current rules, including the rules on authentication of evidence, are sufficient to address any issues. How are our participants in this conference coming out? 80% for yes, 20% no. Very interesting. All right. Let's move on to, we are missing a slide in this copy, but that's all right. I would hold up mine. Tell you what, I will do that. You can see my copy here. And what you've basically got, and I'm sorry, online audience, you're not going to see this. There are two rules that are coming into play here. A proposed federal rule 707, and they had just shut down public comments on that one recently, as well as Federal Rule of Evidence 901, and the committee saying, well, you know, maybe not so fast on this one. Judge Rodriguez, your views on, are we going to face the rule of unintended consequences if we go changing rules?
So there's two different rules aimed at two different things. So the 901 is aimed at the deepfake issue. There, you know, I would personally like to see them pause and wait because, you know, it's not going to be as drastic as this stuff is going to go right in front of a jury and they're going to be hoodwinked, not realize what's true evidence and what's not. It's going to go in the civil process through discovery, and you all will play out whether something's fake or not, bring it to the court's attention. It's not like we're going to be, you know, throwing this out in front of a jury just completely unchecked. And I think we need to play out how this is going to work. 707 is dealing with the use of AI in lieu of experts, or so it's written that way. I'm not sure exactly how that plays out. My good friend, Judge Grimm, is here. You know, he has a different position on this. I'll give you a hypo. I think it's the best way to explain it. Let's say you're representing an employer. They do a RIF. They use AI to calculate who's going to be included in the RIF. I think the way this 707 is written is that the employer has the burden of establishing that the AI-generated RIF, the AI tool done, was reliable, effective, and they've got the affirmative obligation before they can put that into evidence that this tool was good. That seems to flip the usual burdens in a discrimination case. Normally the burden's on the plaintiff to prove I was discriminated against. Here we're going to have a check on the employer. I think there's a lot of unintended consequences by these rules. I vote to pause.
Vote to pause. Judge Matthewman, your vote.
You know, I think that, first of all, I think that we do need new rules. I believe with the 80%. I think that 901 there needs to be a specific rule dealing with AI because I think the burden is too low. Under 901, the burden for authenticating or identifying evidence is evidence sufficient to support a finding that the evidence is what the proponent claims. This AI stuff looks so real. I don't think that burden is high enough, number one. And I think there should be some sort of shifting burden between the proponent and the opponent so that the opponent has to have some level, whether it's reasonable suspicion or probable cause or some level of distrust in the product to require the other side to respond and prove by some burden, preponderance or otherwise, that it is accurate. So I think 901 does need to be amended. 707, I think it's well-intentioned, the proposal. I think it's a little misguided because the way I read the rule, it seems to be intended to allow parties to introduce AI without a testifying witness. I think that's very dangerous. I think cross-examination is very important, and I think the rule should say something to the effect that absent agreement of the parties, AI-generated evidence cannot be introduced without a testifying witness. Whether that's
what
an expert,
they're trying to do, Bill. But you know that's the problem with the rule. Here we are. The two of us can't understand what the rule says right now.
Right,
And I don't agree. I think the rule says something different.
Right. I think
There we go.
I think it's encouraging AI to be introduced without a witness. And I think that is a dangerous concept. At least that's the way I read it. That
Let
may
me
not be
quickly
how it's
read you
intended.
the proposed language. And the section is machine-generated evidence. When machine-generated evidence is offered without an expert witness, there you go, and would be subject to Rule 702 if testified to by a witness, the court may admit the evidence only if it satisfied the requirements of Rule 702 A through D as in Delta. This rule does not apply to the output of basic scientific instruments. And the comments just came out. One of them was, they never define machine-generated evidence.
Or basic instruments.
Or scientific
Yeah.
instruments.
Yeah, a lot.
Right.
So, I mean,
The rule of unintended consequences lives.
Right.
Judge Jones.
Well, on 901, I tend to agree with Judge Matthewman. There has to be some showing by a party challenging a document. What do they call it? The liar's dividend. You can't just say, as people in our society do say, well, that's fake. You got to have something to back it up before the party is going to have the burden of coming forward and showing it's more likely not. As to Rule 707, I think it's well intentioned. I also worry about the fact that, number one, judges are going to have to end up having a series of Daubert hearings, like we do on scientific evidence. We're going to be having that on documents, but different from expert testimony. And under Daubert, we have a hearing and we say it meets the Daubert standards, and then the witness testifies in court. Right. With 707, the document is just going to go into evidence, assuming it can be authenticated, and there's no testifying witness. So how will juries weigh that kind of evidence? Will they consider that better or worse than expert testimony? And then, of course, the evidence will not go through the crucible of cross-examination like you would have with a true expert.
All right, thank you, Judge Jones. We're going to go through, for our remaining moments, Judge Barksdale, you have a choice. You've got your closing thoughts right now. You can answer the rules question, or you can talk about any closing thought you'd like.
Anything.
Anything.
Okay. Well, I'm just going to repeat what Judge Rakoff said in the Hebner case at the end. He said, generative AI presents a new frontier in the ongoing dialogue between technology and the law. Time will tell whether, as in the case of other technological advances, generative AI will fulfill its promise to revolutionize the way we process information. Here's the part I really like. But AI's novelty does not mean that its use is not subject to longstanding legal principles.
Thank you, Judge. Closing thought from the State Courts of Louisiana with Judge Danielle Taylor.
Well, I tend to agree with everything that Judge Matthewman and Judge Jones just said. I think all of those things are up for consideration. And I don't know where it goes with regard to the rules. I know that we have a civil law rules committee that was put together by our legislature, and I know they were studying whether or not we need to make rules about AI. I don't think I've yet gotten a decision or a draft of what they're doing yet. I'm looking forward to seeing that.
The future will tell. The Honorable Julie Sneed, closing thoughts.
I think it is appropriate to continue to study the issue, to continue to think about whether or not there needs to be additional guardrails, additional rules that apply. I think at this point, the rules that have been put forth, 707 and 901, I think these topics are already governed by pre-existing rules. And so I don't think we should create new rules just because we want to, use an old rule and then explain that it applies to AI. I think we should consider heavily whether or not the current rules that we have are already in place. We can never put in a deep fake, right? You could never use fake evidence. Why would you think that you could use fake evidence now? If you had evidence as it relates to 707 that was machine generated, of course somebody is going to be asking, what is this reliable? Is it helpful to the jury? And was it based on reliable principles and methods? And so I just am going to say that yes, study the issue, but don't rush out to stop technology from moving forward, and don't constrain the use of technology by creating new rules, where we already have pre-existing rules that are fine.
Thank you, Judge Sneed. Judge Rodriguez.
I want to turn back to e-discovery tools. So, you know, we're going to obviously have fights over, you know, the prompts, whether they're protected or not, the validation of the products. I hope we don't go back into tar wars and that whole arena. I think these things have promise. Hopefully they'll help us get to just, speedy, and inexpensive. So from both sides of the spectrum, you know, let's not kill something before it has a chance to take off.
Judge Jones, I promised Judge Matthewman the final word because he did not get a first question, but would you like to add anything in this lightning round before we go?
Two very quick points. With AI, of course, it's the norm now. It's becoming more prevalent. We all know it increases efficiencies, but you have to make sure there's a human in the loop when you're doing AI for legal research or when using AI for document review. And then lastly, and this definitely applies to judges, I think we all have to understand the technology, what it can do and what it's doing with your data, so you have in place necessary and effective controls and safeguards. And if you don't understand the technology, you're not going to be able to control it and use it properly.
Thank you, Judge. And the final word with the Honorable Bill Matthewman.
I will be very short because I know there's a reception outside. I don't want to keep you all from that. But the legal system has always confronted new issues. Fingerprints at one point were controversial. DNA at one point was controversial. Emails, all these things were controversial. This is another AI. This is controversial. I do think we need to revise our rules to deal with it. But I think we all need to there's a lot of quotes that I like from this Zen Buddhist monk. I won't tell you his name. One of them is smile, breathe, and go slowly. And I think that applies to artificial intelligence in our legal system. I think overall it's going to be very beneficial over the long run, but I think we need to smile, we need to breathe deeply, and we need to go very slowly as we embark on this AI journey.
Thank you, Judge. On behalf of the Honorable Patricia Barksdale, the Honorable Gary Jones, the Honorable Bill Matthewman, the Honorable Xavier Rodriguez, the Honorable Julie Sneed, and the Honorable Danielle Taylor, thank you for spending part of your day with us. We hope you've enjoyed it. You hope you learned something. Go Gators. Here's Bill Hamilton.